6, 7, 8, 9, 10. Okay, so 10%. That's not a bad percentage. We want by the end of this session to get to at least 60-70% of you having public interest matters. In other jurisdictions, especially in Europe and the Americas, you actually have to do pro bono, and most of the lawyers do pro bono by taking up public interest matters or representing a few clients for free. Public interest is a good area where you can actually represent someone, get the satisfaction that you have contributed to rule of law and human rights in your country. And we are very happy that you came to this training, because this will build in you that spirit and willingness to take up these matters on behalf of clients that are unable to, and to support the growth of rule of law and human rights in the country and region. The president of Uganda Law Society, Mr. Bernardo Undo, who is on the way. The vice president of the East Africa Law Society, Mr. Ramadhani Abubakar, who is here with us. The chairperson of the East Africa Law Society Rule of Law Committee, Professor Frederick Sempebwa, who is also here with us. The treasurer of the East Africa Law Society, Ms. Naomi Biabazaire. The CEO of the Uganda Law Society, our host, Mr. Moses Okwalinga. The representative of the African Court on Human and People's Rights, Mr. Victor Loila. The representative of the Secretary General of the East Africa Law Society and Deputy Treasurer of the Rwanda Bar Association, Mr. Odas Gabo. Senior counsel present, our esteemed facilitators for the day, distinguished members of the legal fraternity, ladies and gentlemen, good morning again. Like I started by saying, we're going to deal today with public interest. This is something that the East Africa Law Society has been working on for years. And if you go to the East African Court of Justice, look at the list of cases that have been filed, you will find we have almost 20 cases. This is the single largest litigation done by an entity at that court. And this has been done by our members. Professor Sempebwa is in the room. He has represented the East Africa Law Society in many of these cases. We want the upcoming group of lawyers to take up that space too. We want to challenge our governments. We want to remain within the realms of rule of law and human rights and good governance in the region. And we have noted, and this is with a little bit of concern, that Uganda needs more work when it comes to public interest litigation. That we need more Ugandan lawyers taking up matters of public interest. I know this calls for courage. It calls for, to some people, a calling. You have to feel it from your heart to represent someone, because it has risks. It doesn't come easy, because you are standing up sometimes against the authorities. And you're standing up for something that is not popular within your country or within the region. And so it has faced some challenges in Uganda in the past. In fact, we have been monitoring a lot of what is happening. Sometimes you represent someone, and the next day you know your law firm is ransacked, or you are arrested, or something happens that you can't explain. So Uganda has been on the radar, on the spotlight for us. And the reason why we've started these sessions in Uganda is because of that. There's a bit of challenge when it comes to Uganda, especially for lawyers. There's a bit of fear, and that's the reason why we are bringing this here. Another challenge that we've seen in Uganda sometimes is inadequate resources. Because if you are to represent someone adequately, then you have to have some bit of resourcing and support. And the resource is mostly financial, but sometimes also technical. We've also seen in Uganda judicial delays or delays in the judicial process. And as public interest litigants, that's a big concern to us. The other thing that we've noted is the limited public awareness around public interest litigation, especially among the members of the legal profession. Most of us do not really want to take up public interest litigation. Most of us say this is human rights. I'm a corporate lawyer. I want to make money. Unfortunately, this area does not have much in terms of remuneration for you. You will not expect a heavy pass if you're representing someone whose rights have been abused, or if you're going to court over a constitutional violation or something that is basically not going to put money in your pockets. And so we're trying to build that team, that cohort of lawyers that can take up these matters. And this particular course is a precursor to what we are preparing. We are preparing a regional practice fellowship program. And I'm announcing this for the first time. A regional practice fellowship program where we're going to train fellows to take up public interest matters. This is intensive training, not one-day sessions like this one. You're going to be taken up, say, to Arusha or somewhere else that we'll select, and you're trained for a full month, and then assigned a case to prosecute. So those are some of the steps that we are taking to make sure that strategic litigation, public interest litigation comes to the forefront in the region. With that, we have organized and put together a comprehensive session with very experienced facilitators. And these facilitators are going to share with us their experience and above all their knowledge in this area. We expect that by the end of our session today, we go home inspired that yes, this is something we can take up. Not for money, but because we want to add value to our society. So as we look forward to hearing from them, ladies and gentlemen, I once again welcome you to this session and really thank you for coming. I wish you fruitful deliberations. I'm going to take this back to the MC and our host CEO, Mr. Moses Okwalinga.
Thank you so much. I'd like to request Mr. Moses Okwalinga to please come and say a few words.
Good morning, everyone. I would like to begin by thanking all of you for making it here today for this first ELS event in Uganda and across the other countries as well. We are glad that ELS found Uganda to be fit as the first place to carry out this training. The executive of the East African Law Society, without offending persons by mentioning wrong names, allow me recognize the executive of the East African Law Society, the CEO of the East African Law Society, the executive of the Uganda Law Society. Our president will be joining us shortly, as well as senior members of the bar, senior counsel Professor Frederick Sempewa, senior counsel Mr. Ogalo, our facilitators, colleagues from the legal profession, the secretariat. Allow me welcome you all, as well as the ELS secretariat. Gabby and the team, allow me welcome you to Uganda once again. We are glad that we are having this training on strategic interest litigation. This is an area that we as Uganda need. Without going into details, we can all see what is happening around this country. So we need more bolder, more deliberate steps in the area of strategic interest litigation. It has shown that it's an area that can effect change. It may take a while, but it's one of the most evident ways of effecting change in the nation. So I'm glad that we're having this discussion, and I'm glad that we have the right people in the room, from the membership and from the justice sector on the whole. On behalf of the Law Society, allow me to thank the ELS and all our partners for making this possible. And I wish you all good deliberations. Thank you very much.
Thank you very much. At this juncture, I'd like to invite the Vice President of the East Africa Law Society officially start this session.
Uganda Law Society Council and the Secretariat present, Professor Frederick Sempebwa, the Chair of the ELS Rule of Law Committee, the ELS Secretariat and Council members present, Mr. Victor Lowila, representative of the African Court of Human and People's Rights, distinguished members of the legal fraternity, ladies and gentlemen, Mwasuze Mutia Vasebo Nebanyabo. I cannot hear a response. Mwasuze Mutia Vasebo Nebanyabo. There should be a response, right? Burundi. Perfect, perfect. This is a beautiful morning. Yeah. What many don't know is that Uganda is also home for me because my mom is Ugandan. Yeah. So I'm a child of East Africa. Yeah. She lives right down here. Is it here or here? In Tinda. You know, it was this side. Yes, yes. Yeah, and my dad is Kenyan, so I'm a child of East Africa. Yeah, it's a pleasure to be here. Let me take this time to welcome all of you warmly to this particular CPD or CLE seminar. I stand here representing the president of the ELS, Dr. Fauz Twaib, and the entire ELS Council. I wish to express our deep appreciation to all of you for setting time aside from your busy schedules to attend this particular very important training this morning. Strategic litigation, or otherwise known as impact litigation, is a crucial aspect in every lawyer's practice. When I was 2 years in practice, I had the opportunity of attending a training here in Kampala at the Speak Hotel Munyonyo, where it was organized by the Media MLDI, Media Legal Defense Initiative. That was 2 years in my practice. And I can tell you for a fact, that training had a great impact in my practice. Now I'm hitting 11 years in practice. I think you should clap. Yeah, so after this particular training, Professor is laughing because 11 is too. I'm still a young lawyer. Anyway, so after this particular training, I had the chance to represent several clients in pro bono matters. Yeah, and in 2019, the Law Society of Kenya and Amnesty International awarded me pro bono and public interest litigation jurist of the year. Yeah. You'll understand not many lawyers win awards. So, so this particular type of litigation can make you recognized. See it as a very important part of your practice, even at your law firm. You need to have a department, a pro bono department, a public interest litigation department that conducts this type of litigation. Because for me, I believe human rights, or rather, when we all, I'm assuming many in the room, when you all wanted to be lawyers, it was the aspect of changing the society, having an impact to the society. Yeah, corporate law is important, but also practicing in areas of law that have an impact in society, I believe, is more important. Because there can never be economic progress if there is no respect for the rule of law and human rights. So I had a speech prepared, but I will try just to speak off the cuff for reasons of time. Yeah, as you can see I've just seen from one of the mandates and vision of ULS is fostering the rule of law. We share this mandate with the ELS. Therefore, it is an obligation upon these two bodies to ensure that the rule of law is exercised. After this training, my hope is that we'll have ambassadors in strategic litigation from Uganda. Yeah? We cannot have, the next time we're having such a session, when Mr. CEO Sigano asks members to raise up their hands, it'll be more than 70%. Yeah, take this training as a very crucial training in practice. I also wish to announce that we shall be preparing an index on, that is the ELS. We'll be preparing an index on the rule of law. It will be the first index, yeah, that will be prepared. This index, its purpose is to measure which East African country is implementing the rule of law principle. Therefore, there will be a ranking for the East African member states after this exercise by members. I'm sure we all saw the call for applicants. So the ELS takes the issue of the rule of law seriously, and we do undertake to continue pushing and opening these doors in matters public interest litigation. I'm sure you're aware that we now have a case at the East African Court of Justice on the issue of the media, the internet cutoff and where the internet was cut down during the campaigns. So we have a case pending, and we hope that for a favorable outcome. But we are working hard to ensure that we represent the matter to the best of our ability. And with that, ladies and gentlemen, I don't want to say much. I wish to thank you all for making time to come for this important training, and I hope for fruitful discussions. Let it be engaging. Let's ask all the questions so that by the end of the day, we are better practitioners. And with that, we're burying you all. Thank you. Naomi?
Asante sana, Rais. Now that you've spoken Uganda, I should also speak Kiswahili. Tumeshukuru sana. Ladies and gentlemen, we're going to the next segment of our training this morning, and we'll be moving to the first presentation of the day that is going to be made by one of our very senior colleagues who has been in practice from 1982, before the revolution that we now live in came into place. So he's going to tell us more about the context of public interest litigation. And I'm sure his presentation is going to take us through the origins of public interest litigation, and he will try to also make us understand the global history of this litigation and its context in the country. Ladies and gentlemen, our presenter, the Honorable Wandera Ogalo, is currently managing partner at Victoria Advocates and Legal Consults, and he's a practicing advocate of the Courts of Litigation in Uganda and the East Africa Court of Justice, and he specializes in constitutional, administrative, electoral, and human rights law. He's personally taken forefront on big public interest matters, like the Uganda Law Society age limit petition that went from Constitutional Court to the Supreme Court. He was lead counsel and a man at the forefront of that. And there's no better person suited to give us this presentation than the Honorable Dan Wandera Ogalo. So without further ado, ladies and gentlemen, let's put our hands together and welcome the Honorable Wandera Dan Ogalo to come and give us his presentation about public interest litigation. Honorable, you are welcome. Once a honorable, always a honorable.
Somebody had forgotten his phone here. morning, ladies and gentlemen. Let me begin by disagreeing with Gabriel that once honorable, you're always honorable. That's not true. When you leave parliament, that seat is taken over by somebody else who is referred to as honorable for that constituency. It is a pleasure and a privilege for me to have this opportunity to share with you a few thoughts and experiences on this very important subject matter. Oloko Nyango defines public interest litigation as a means by which we challenge governance structures which promote oppression, repression, domination, and also challenge that framework that creates inequalities, marginalization. From that definition, you can see that it is a very important subject because we are dealing with the people. You are dealing with the quality of life. You are dealing with freedoms. It is there in you. All of us have within inner, something inner to do this, to do public interest litigation. It is also in our own interest that we challenge those frameworks which create inequality. It is also in our interest that there is good governance, because you can't practice if there is bad governance. If society has collapsed, if there is a complete failure of rule of law, where will you practice? So it is also in our interest as lawyers, apart from the Ubuntu, apart from the fact that as a human being, this is an obligation. You may not recognize it, but it is there within you. Apart from that, it is important that you sustain rule of law so that you can be able to carry forward your practice and be able to do well in your legal practice. Internationally, public interest litigation has been used to ensure that human rights are not violated. It is not just an academic thing to say human rights. No, it is about life. And in my paper, which will be circulated, I've cited some cases like a Brown versus Board of Trade. It's an American decision of the Supreme Court of America, from which you will see how liberalization, how society can be transformed through this kind of litigation. You are all conversant, you've all read about the segregation and discrimination against black people in America. To show you that these litigations are what helped to at least get them to breathe. Things are still good, but at least they are better off than they were. Recently, you must have read that a very long-standing precedent, Roe versus Wade in the United States of America, which has been there for over 50 years, And it was achieved through the litigation to ensure that the rights of women are protected. And for 50 years, the American woman has taken it for granted that she has this right. The American woman has gone a long life knowing that these are things she is entitled to, only for the Supreme Court to tear it down. And now you begin all over. So these rights will be fought for. It is a continuous fight. If in Uganda here, the Women Association of Lawyers versus Attorney General, that decision is actually a reflection of those kind of rights we are talking about in Roe versus Wade. That even in Uganda here, the rights of women have had to be fought for through public interest litigation. In India, the Supreme Court had to make an about turn. Originally accessed by poor people, by people who are disadvantaged, it was difficult for them to access the courts. But in that paper, in that publication of Oloko Nyango, which I've cited, the Supreme Court in India realized the necessity of having the rights of vulnerable people listened to and addressed. In South Africa, I've given in my paper decisions where the court has through this kind of litigation ensured access to water, access to health. So it is clear that this kind of litigation can transform lives, can change lives, and that you are in a position to do so if you put your mind to it. And in order for us to see what really is a public interest litigation, we can have recourse to a body in Australia, which normally deals with what amounts to public interest litigation. And it has laid down 4 criteria. Does that litigation include a significant number of people? Does it raise matters of public concern? Does it impact the vulnerable? And is it legally for the common good? So we can be able to identify through such a definition what amounts to what you should take up, what you should look for when you are going into this litigation. The presidential elections petitions in Uganda, both 2001 and 2006, Dr. Kizza Besigye versus Yoweri Museveni, both of them at the end, when they came to the question of costs, seemed to expand because they ordered for each party to bear its own costs. They seem to indicate that this is for the public good, it is not for you. It is not the 2 candidates who are contesting before the Supreme Court, but they are doing it on the behalf of Uganda. So on the question of the cost, they said, no, you are doing this for the public. Now, what is the legal framework for public interest litigation in Uganda? The first is the Constitution itself. The 1995 Constitution, in respect of the Bill of Rights, I'll first of all talk about the Bill of Rights, was an improvement to the Bill of Rights from the 1967 Constitution. And that improvement has had the effect of opening the gates for private interest litigation. How has it done that? First, it includes second generation rights, which were not there in the 1967 Constitution. Second, it brings administrative tribunals, Article 42, it brings them under the umbrella of rights. Then in Article 43, it creates a new yardstick to compare what Uganda is doing with what is acceptable in a free and democratic society. And then it brings in rights which are not derogable. You cannot move away from them. So to an extent, the 1995 Constitution expanded the platform on which you can stand. You have more work because it creates a wide field of areas in which you can litigate. You can't say that the subject matter for you to litigate is not there. No, you can't. It's just too much. You cannot even finish it. Even if we were 5,000 lawyers practicing in Uganda, would they be able to finish it? It's too wide. The second aspect of the Constitution is the national objectives and directive principles of state policy, which is not there in the 1967 Constitution. But its effect is also the same as I have said, to widen the area for us to be able to challenge bad governance, to challenge the framework which causes inequalities. How does it do this? Article 8A, the new amendment, which brought in good governance, directly links good governance of Uganda to those directive principles of state policy. In other words, whenever you read those principles of state policy, link it to good governance, and therefore be able to recognize that being interlinked, there is an opportunity to do litigation in that area. Then they bring in, those principles bring in two things which are also very fundamental. They require government, the state, not even government, the state to fund institutions which promote human rights, to fund and respect them. That would be, for example, the Judiciary and the Human Rights Commission. Now, if they are properly funded, they will be efficient, they will be effective. If they are effective, litigation, private interest litigation, will also prosper. Secondly, they also require the state to recognize non-governmental organizations which promote human rights. And these non-government organizations in Uganda have been at the forefront of fighting have been at the forefront in this litigation we are talking about. Many of the cases you will see, both in the Constitutional Court and the High Court, touching on fundamental rights and freedoms, you will normally find these non-government organizations as parties, have been very instrumental. And the Constitution says the government should respect and promote them. But what do we have instead? Instead, you have these non-government organizations, their offices being raided. You have their bank accounts being frozen. You have their activists being beaten up. Now, it is puzzling. If in